I want to tell you about a new court decision that highlights an issue that comes up a lot when we're reviewing harassment policies, and that is what do you do with somebody who's made a false complaint. This is a court decision out of the federal court for the Eastern District of Tennessee. New case, it's called EEOC v. HP Pelzer Automotive Systems. Might get appealed to the Court of Appeals. We'll see, but let me tell you just a little bit about the facts and the holding and tell you what I think it means that employers need to be thinking about on this topic. So this was a new employee, and she was at orientation, last name Black. Ms. Black basically had a couple of complaints about things that were said at the orientation. One was that the manager doing training said, "I don't want to see no crack," as in rear end, regarding dress code, and it purportedly said to Ms. Black, "Drop your pants and I will take a picture of you and use you as an example." That was one of the comments. The second one, at another meeting, supposedly the same manager said, "Only way you women will understand is to be yelled at." She made a complaint about harassment. The company talked to a couple of other people who were present. They did not verify or corroborate that these statements were made, and Ms. Black was terminated for a false harassment complaint. Long story short, there's a lot of legal stuff in this opinion. I'd be happy to send it to you if you want to email me, I'll send it to you. But the court ultimately denied summary judgment to the employer on Ms. Black's retaliation claim. Said that it could not conclude from what was before it at that point that she might not have a claim before a jury, because ultimately the parties agreed that she had made a harassment complaint, disagreed on whether it was true or not at a summary judgment stage. Generally, the court has to take what the plaintiff says as true. And she had a good faith belief, the court said, and sent the case forward. No doubt after the employer had spent a lot of money defending this. So what we often see in a policy setting is a statement, and it's just, so you can just see it's really hard to win that kind of case for an employer if that's all you got at that point for what seems like a relatively minor issue. I often encourage employers at the policy stage to just take out the sentence that says people will be disciplined up to and including discharge for making a false complaint, because, as I've said in other videos, I think it's so important that we do everything we can to encourage reporting. If somebody makes a false complaint and you really got them nailed on it in a way that it doesn't sound like this employer probably did, you're going to be able to terminate them, I think, without saying it in your policy. Lying is one of those things that most decision makers understand. So if an employer can prove it, I don't think you need to say it in your policy, and I have a concern that when you do say it in your policy, the people who are debating, should I report this or not, which we know happens a lot, it may be what discourages them. What if the employer finds something else? What if I get disciplined for that? So that's usually my advice on the policy. I think this case, it's just one case, it's just one scenario, may or may not be how you would handle the same scenario in your workplace, but I think it underscores the difficulty with that kind of statement and those kind of situations.